serendipitous listens prepare to witness the sign sealed and delivered. Spit for me, it's just Mr. Kid's benefits. You're reaping with of air you're perceiving, but not from breathing. I mean an air that's lack of the seeding, whose depth is reason. Professor one expecting the will, and that's a testament to youth. Fresh from adolescence when he was killed in the wreckage. It's 18 with great dreams, big goals so never reach. Oh, what a messy lead, you see. It's death without a woman's untested. Success inside a loss, so we divide his possessions. Possessions? I'm guessing you just said it, you question. He's just 18, so what the hell you expecting? He's barely lived, and guess by how he died in their records is very negligent. $50,000 his mama get as a settlement. Mama was set it seems. Her daddy, who's barely been around, came around and contested, hoping he get it. And testing successes as when a death in Pennsylvania happens to an unwed man with no kids and folks split the bucks. If bro would've known that both his folks would get a cut, he'd be sick enough. If there was a will, he could advise a way to have that or not his pay. But nowadays, mom's got a fight to take, and at just 18, I wouldn't try to blame my boyfriend. I'm trying to make a plan for his estate, but I'm trying to save. Just take heed. This can happen whether you're 80 or 18. If you have 1 cent to your name, please believe it's never too soon on estate plan, because any day death can hit. So don't complicate things. Your fam will go through an overview of documents concerned for you, but before I do, remember this rule that I say to you, and then I'll conclude. Simply plan your estate before the state makes plans for you. Simply plan your estate before the state makes plans for you. Simple estates in PA here today. Let's begin a slow overview. And so with no ado, we're gonna open with wills as our focus, and then what you notice will shift to the others. What is a will to an heiress or boa? When you prepare when no errors gonna come up, heirs of he who inherits a dead man's possessions through laws of intestacy. Where there's a will, no one heir, there will never be wills to control over property goes. After your death, indeed, whether to family or to a charity or to a charity, you pick the designee. For who get your things, will or personal, per the terms you wrote, they should be there and the language is clear. Plus you get the name who can handle affairs when you're no longer here. That person we call an executor, that's your representative to settle estate and pay taxes and debts that are ethical. In addition, my friends who distribute your things, make sure they get to the people you name. Plus the will can make revisions for minor children and those with mental impairments that can't take directly. You just need to meet these prerequisites, and PA per statute Jamaica will actually just be 18 and have the mental capacity. If it's in writing and signed by the seat, and that's all that you need to probate this thing legally. Still, when a signed will is so proven, then probate runs smoother. That means the signature is witnessed by 2 independents that don't have an interest in gifts that you're giving. It should be notarized, sealed, and delivered, and that's all the proof that you need that you did it. Rules are a must to dictate where your stuff goes on houses, the clothes, bank accounts that you own, possible some trust business interests and such. You can make as many rules as you want. You're not stuck with a document. As long as you're competent, you can change or revoke what you got, my friend. And there are other aspects of the will that we'll discuss at a later time, such as the probate process itself, dealing with inheritance taxes, as well as the interplay with revocable living trust, which I know there's been a lot of interest in recently. Now, all that stuff focuses on what happens to your property after you die, but estate planning also deals with how you like to have your affairs handled while you're still here, particularly when you get older, you're dealing with illness, and you're less capable of handling your affairs. How do you handle that, you may ask? Just listen. Let's talk of paradox, no contradiction. One's POA and the others are living. Will. Both govern decisions for people while they're still living. We'll break them down with precision. First the definition. Other first doc, well, spell the initials. P is for power, O this means of. A's an attorney, that here's what it does. Whether specific or general, a POA lets a principal pick his own person to stand in this place to handle his things. We have a name for this person, an agent. You as principal, name him. Or if he's not a runner, replacement. Now a principal is what I'd equate to a boss if this war work situation. Now similarly, just as bosses are to employees, principals or the agents. I'm just saying, it's an exercise in delegation, okay? And the duties you give him should be broad or limited to paying bills, telling land in those gimmicks. All of his actions should be in your interest, because if it isn't, your agents don't get it. Just as with wills, you should be grown incompetent. OPOAs that you make and be China's kid. State of mind in this, state context is also pertinent. We gotta watch for it with the elderly. You know that mind can slip at this vulnerable time when you're trying to assist. To avoid complications, your doc should address the duration of POA, which is durable, is what you usually use in this here situation. That just means it is good when the sign is still good if the principal's mental escapes him. That's the fault when the power is durable. But if you choose, you can have it start later on the happen another condition. That is when we call us bringing POA, son. And PA, son, POAs need a principal's signature. Inputs to witnesses. basis, and it should be notarized by the time it was signed by the principal. But we're not finished yet, cause to be legal, you're gonna need an acknowledgement signed by your agent addressing his powers, kid, and PA's requirements for your agent. Okay, so we touched upon the power of attorney, the POA, but there's still the matter of the other document we mentioned, the living will. Again, like the POA, you draft this to govern affairs prior to death. And typically, when it comes to living wills, I like to refer to a specific example. Listeners might know Terry Schiavo. Terry died in 2005, though. Terry lived for about 15 years undefeated. That was the state of affairs down in Florida, though she was basically dead. At the time of this case, it was big as a family fuss over pulling the plug when she left no instructions, you dig? And it's the gist of what we're trying to fix. When we have a living will to repair, you might know this is a healthcare directive. Essentially, here's what it is. This is the type of power of attorney in which an agent handles affairs medically for the principal, particularly when an in-state condition exists, one of which death is deemed imminent, or when the principal suffers brain damage that cannot be fixed. So there's no hope for recovery. Principal's life quality now is going to be minimal. In this situation, we're going to give the principal a saying. I was agent, should approach these conditions on what kind of treatments will take, man. If you want life support, you could say it, or have them put a plug when your brain dead. It's so spirits to trouble or family rumbles when the principal's vegetated. Living wills also cover donation, designations for organs and tissue, and no need for notarization when you make one. Though that's my recommendation. Like the others, adults get to make them, and if you name your spouse as an agent, you should know upon divorce that position turns vacant. Now in my estimation, I think we've touched all the bases in a simple estate plan.